This morning, June 27th, 2025, the Supreme Court issued its decision in Trump v. CASA, that is, Citizens Assisting and Sheltering the Abused, with the additional plaintiffs being the states of New Jersey and Washington. Trump v. CASA is a case about nationwide injunctions. Now, what are nationwide injunctions? They're a practice by which a court doesn't just enjoin or temporarily suspend a law or executive order with regards to the specific plaintiffs, but does it for the country at large. There are essentially two things a court can do when faced with a lawsuit and it decides in favor of the plaintiffs. It can say, this decision is only going to apply to you, specific people engaged in this lawsuit, and so the law does not apply to you, and then other people for whom that law might apply can also file suit in their respective districts and get relief for themselves as well. Or a court can say, we're just going to apply this nationwide. We're just going to say that there are people like the plaintiffs that exist in every state of the union, and to ensure that they are not affected by this law that we feel, or this executive order that the court feels is unconstitutional or exceeds the Congress's or the executive's power, we're going to suspend it nationwide pending further appeal. Nationwide injunctions have always been possible in the American system of jurisprudence, but they weren't really common until quite recently. They hardly existed in the 19th century, were rarely used throughout the 20th century. More often, you had a situation where a court would decide in favor of plaintiffs, and then other people would also sue in order to get relief. And the nationwide injunction really only came to prominence in really the last few decades, since the 1980s. And in the last 2 decades, specifically beginning during the Obama administration, they came into much greater use, with federal courts issuing nationwide injunctions on a somewhat regular basis. They've been especially prominent in use against the Trump administration, the Trump administrations, both from 2017 to 2021 and this year, at the beginning of the first Trump administration. And this particular nationwide injunction in this specific case relates to the Trump administration's executive order, essentially suspending birthright citizenship. What is birthright citizenship? Well, it's a provision under Section 1 of the 14th Amendment that says, in short, that if you are born on American soil, then you are an American citizen, irrespective of who your parents are. We have this provision in the Constitution, in the 14th Amendment, because of the Civil War, and really because of the Supreme Court's ruling in the 1857 case, Dred Scott v. Sanford. In Dred Scott, the court held that Black Americans could not be citizens. They had no rights the white man was bound to respect. Opponents of slavery, in particular abolitionists and members of the Republican Party, were outraged by this decision and made overturning Dred Scott a key part of their party platform and of their political efforts. Section 1 of the 14th Amendment was written specifically to overturn Dred Scott and to ensure that Black Americans had citizenship. Now, what's interesting about the birthright citizenship clause is that its creators did not think of it as a narrow thing. They did not think it just applied to enslaved Black Americans and their children. This was by necessity. The population of enslaved Black Americans included people who were illegally imported into the United States, and thus were not born in the United States. They were brought there. And the authors of the 14th Amendment wanted to make sure that them and their children were included under American citizenship. And during debates over the citizenship clause in Congress, advocates for the clause readily admitted that this would apply to basically anyone born in the United States, whether they came from Africa, whether they came from Asia, whether they came from Europe. Remember, this was during a period where there was broad anti-immigrant sentiment. The Know Nothing Party had been quite prominent in the years prior. There was Chinese migration to California, and there was wide anti-Chinese sentiment. And even in the midst of all of this, the Republican authors of the Citizenship Clause insisted that it applied to everyone born in the United States, regardless, again, of where their parents came from. And the Supreme Court affirmed this in 1898. The only people that the clause did not apply to were the children of diplomats who were not subject to the jurisdiction of the U.S. government, and for a time, Native Americans whose tribes retained their sovereignty vis-a-vis the United States federal government. But if you fell outside those categories, a member of a Native tribe or the child of a diplomat, then you were a citizen of the United States. That's what the amendment plainly says, and that's what the intention was, as it was written in 1868. Now, President Trump issued this executive order, essentially suspending this in the country, and naturally there were a lot of lawsuits because this was straightforwardly unconstitutional. First of all, the Constitution, again, is clear on the meaning of birthright citizenship and all the historical evidence strongly supports the straightforward reading that this is just a general application of what its authors thought was a natural right, that if you were born in the United States, if you're born on American soil, you're an American citizen. But also, the president cannot unilaterally suspend the Constitution, cannot unilaterally change entire constitutional provisions, rewrite constitutional language. The lawsuits make their way to a federal court, and a federal court doesn't just block the executive order for the particular plaintiffs, but issues this nationwide injunction. The rationale for this nationwide injunction is that it's actually very important for there to be a uniform standard of citizenship across the entire country. A patchwork of citizenship rules would lead to complete and total chaos. And so, pending appeal on the merits of the president's executive order, this federal district court said we're going to suspend the directive. The Supreme Court is not dealing with the merits of the order. The Supreme Court is dealing with this question of nationwide injunctions. And in a decision written by Justice Amy Coney Barrett, the court says that this kind of nationwide injunction is basically unconstitutional, that a court cannot issue this kind of broad relief for every potential plaintiff. That if you want relief, you either have to file a separate case or join a class action suit. The dissenting justices, and specifically Justice Ketanji Brown Jackson, says that this is ridiculous, that you're giving the executive a prerogative power, the ability to suspend constitutional text pending appeal, and that this kind of prerogative power is incompatible with the rule of law. You can't have the rule of law when you have a system whereby the executive can just violate the law, violate the Constitution, and everyone else has to sue separately, has to take separate actions in an effort to get the courts to restrain a blatantly unconstitutional action. Even class action suits were difficult to put together, and this court specifically has made class action suits more difficult, and it takes time to get them together. And so while you're putting together a class action suit, you're allowing this violation of rights to stand. And while today it is birthright citizenship, it could be gun rights under a future president. It could be the right to worship under another. The majority, it says Jackson, has created a law-free zone by which presidents can operate without any real challenge. It is a recipe, she argues, for unraveling constitutional government. The majority, Justice Barrett, says that this is nonsense and that what Jackson's describing is an imperial judiciary. I find this quite ironic because to my mind, there's nothing more imperial than an executive rewriting a core constitutional protection essentially on a whim. In that it's the role of the judiciary to protect these baseline rights, to say what the Constitution means, say what the law is, and to make sure that there is harmony and uniformity in its application across the entire country. To say that this constitutes imperial behavior is to essentially abdicate the role of the judiciary in our system. And it's also to implicitly advance a vision of the presidency by which the president isn't simply an executive officer tasked with upholding the Constitution and executing the will of Congress, but some kind of avatar of the people themselves for whom any kind of opposition to or resistance to their will constitutes some assault on the people. It's a vision of the presidency that in another time, another place, was called something like Führerprinzip. But we can have that discussion later. Now, what does this ruling actually mean in practice? First, it means it's going to be much more difficult to challenge the unlawful and unconstitutional actions of the Trump administration. You can't just get to a federal court and hope that they'll issue a nationwide injunction, because they can't. You have to, again, have a class action or file similar suits in many different jurisdictions. And with regards to the president's birthright citizenship order, it is likely to result in it going into effect in most states of the union. But there will be many others where it doesn't go into effect. I think the split is something like 28 states it will go into effect and 22 it will not. And so we'll have a patchwork of citizenship rules. In this patchwork, if you are the child of non-citizens, your rights will vary depending on state borders in much the same way that if you are a pregnant person, your rights vary depending on state borders. I want to end this little discussion by noting the similarities here to that of free Black Americans in the antebellum United States. There were large populations of free Blacks above the Mason-Dixon line and even in some places in the South. But because there was no nationwide standard for citizenship, no nationwide standard for the rights of citizenship, the rights that free Black Americans had varied from place to place depending on where they were within the United States. It may change if they crossed state lines. What this meant is that they were in tremendous legal jeopardy if they decided to travel. If you had to move from Ohio through Kentucky, you might end up getting enslaved because Kentucky was a slave state and Ohio was not. If you were, say, a sailor in Boston whose ship was in port in Charleston, you might be taken from the ship and thrown into jail because of the laws of South Carolina. The fraught nature of the right to travel for Black Americans in particular, but just of their rights in general, was a major political issue before the Civil War and contributed to the polarization around slavery that emerged in the 1840s and 1850s. Our court has essentially created some version of that scenario in which your rights increasingly vary from state to state, where moving between state borders may have huge impacts on your ability to live your life. You may have reproductive freedom in one state and you won't have it in another. And if you happen to run afoul of law enforcement in the state where you don't, this could have real consequences. You might be a citizen in New York, but not so much in Montana. And if for some reason you find yourself traveling through Montana as a non-citizen under the state's standards for giving out citizenship, you may find yourself deported, despite the fact that in New York State, under New York law, you are a citizen of the United States. It's a very dangerous situation that the court has created. It's creating chaos where there was none and abdicating its role as a guarantor of constitutional rights to the whims of an authoritarian president. The very last thing I'll say here is this also all puts lie to this idea that you can vote to protect yourself at the state level and not worry about what happens at the federal level, that you can protect state rights and federal standards are just irrelevant. No, they're in a relationship with each other. The federal government can set a floor. It can also set a ceiling. And what we're witnessing are courts working with the Trump administration and reactionary states to set not just ceilings for the kinds of rights you have and can exercise, but also limit how other states can protect your rights. This is coming. This is part of the project. If you want to defend your rights at all, you don't just have to operate at the state level, you have to win federal power as well, because you can use federal power to restrict rights just as easily.